General Pathan, welcome.
Thank you, Chair.
Are you ready? We can proceed.
I am ready.
Did you find each other with the advocate?
I suspect we did, Chair.
Okay. I want to hear you saying, I'm convinced we did.
Well, let me say the following. I'm convinced that following what is in my affidavit in dealing with the issues, it's going to make us make good progress.
That's very important. Thank you so much. SC, can we run until 17 hours? When I say until 17 hours, I mean, okay, let me say the next break will be at 17 hours. Thank you.
Thank you, Honorable Chair, Honorable Members. Welcome back, General Paslani. So the issue of your dismissal, which you contend is unfair and unlawful, that we've dealt with. That's out of the way. You say there's still a Labour Appeal Court decision that's pending.
Yeah, I thought, Chair, we must move away from that one by allowing me to close it with these paragraphs which are in that particular portion, and then we can go to the 360 that you were making reference to, without going into the details, whether it is the arbitration or the Labour Appeals Court. And somewhere I think me and Council are talking past each other, because unless I have it wrong, you talked about the arbitration. Now there are two arbitrations. There is an arbitration award that relates to the 360 that led to the payment of the 360, and there's a triple SBC award. Now that award, the Labour Court judgment, is a subject of the current pending matter before the Labour Appeals Court. Therefore, I don't think I will want to go too much into that. We have said a lot. What I will talk to is the arbitration award, the Judge Haramse arbitration awards that relates to the 360 and the awarding, the subsequent payment of the 24 million. But I thought maybe just to close off the issue on the dismissal, just to sum it up, if I'm allowed to refer to those paragraphs in my affidavit.
Yeah, you may do that if you enter. But I just thought that I agree with you. And just for purposes of clarity and to honourable members of the committee, we are talking about the same tender. That's the 360-degree camera. But in relation to the one arbitration award, which involves your dismissal, that is your conduct in relation to that tender and that contract. Then there's the other award of Harms, LTC Harms, the appeal judge, retired, where he confirmed the payment of 24 million. The tender itself, the 360-degree camera tender itself, is worth over 90 million. The arbitration award of Harms was when there was in inverted commas, settlement agreement, which did not involve you at all. And that is also the nub of your complaint. You were not consulted, you were not asked. It was actually a settlement agreed to by National Commissioner Sitole.
All right. I think this is where now I'm very calm and I'm going to relay the facts so that the disinformation is not continuing. Council just referred to 92 million. Haramsa's judgment has got nothing to do with 92 million.
Yes, I agree.
92 million is the bid, the same panoramic contract bid camera, the 360 cameras, forensic services. When the contract was awarded on the 28th of July 2014, the value of that contract was 92 million. Now, it gets awarded. Once it is awarded, obviously, my environment, forensic services, is the end user because these are cameras that are used by crime scene experts. So ordinarily, we are to place an order and buy from that particular contract. That contract is awarded to Etemba. So before even we can place an order, a competing supplier, who in this case happened to be FDA, writes to supply chain management as a division, the place where contracts are being managed. They are the ones who awards and so on the contract. So they raise an issue with supply chain management, wanting to inquire on which basis was the bid awarded to Etemba, because at least them being in the industry, they knew what the camera offered by Etemba specifications are versus what camera they were bidding for. They responded to the bid for. So once they raised the issue with supply chain management, I think the letter of FDA, which is part of the records, was the 22nd of August 2014. They now, supply chain management, instead of them dealing with the complaint, they opt to send it to me in forensic services. When I received that complaint, which is an issue raised by FDA, I then put together a team of experts, the same managers, the same team that compiled the specifications. I put them together to say, here is an issue where supply chain management is requesting our input. So they revert back to me and say, indeed, they have looked at the specifications against the product that is offered by Etemba, and they concluded that that is not compliant with the specifications. In other words, supply chain management awarded to a bidder who did not comply with the specifications. I then write back to supply chain management to provide them with that information, to say, you have awarded a contract to a supplier and we are not going to be able to use these cameras because they don't meet specifications. And counsel, you're correct. That contract is worth 92 million. So there was to and fro in terms of communication. We said to supply chain management in my letter, which is here on the records, 22 October 2014, go into a process cancel. When we say cancel, we don't mean you must just immediately receiving our letter cancel. They must go together with legal services into a process of engaging the supplier and say, we have established the following. The issue there was that even the bid evaluation committee, when they made their submission to the BAC who awarded, they did indicate the non-compliance by the Etemba bid. Heavens knows why that contract was awarded, because the BEC is saying to you, this product does not comply with this thing. For example, one of the requirements was it must be a 360 camera. It must not allow manipulation. You must not stitch images together. But the Etemba product, you stitch, you do 90 degrees, 90 degrees, 90, which is, you now piece together the 90s to make it 360. Now that is unacceptable. You can't go to court and present such evidence, because the chances of the courts and Leonard friends arguing, but you have manipulated, and they are great. So that thing has got no value. Now, long and short, consistently as forensic services, we have given feedback to supply chain management and say, we can't. Supply chain management went even to National Treasury to say, how do we deal with this contract? National Treasury comes back to them and say, subject this contract to an independent assessment. That time, I'm acting national commissioner. The supply chain management and legal services write a note to me. It is here. I think it's JKP4. In the submission, they say, can we take it for an independent assessment? 23 November 2016, I agree and say, take it for an independent assessment. I think also there is an email here where the same supply chain management people communicate within themselves and say, the acting national commissioner said we must defend the litigation, take it for independent assessment. But I can tell you that today it is not dealt with. So when we talk about 92 million, you are not talking about 92 million in respect of Haramse. You are talking 92 million in respect of the July 2014 contract. Now, I'll repeat it here. I refused to order from that contract because the experts were never going to use that camera. How do I order something that is going to be a white elephant? They were never going to be able to utilize the cameras. So fast forward, having refused, and even people after me in forensic services refused and say, we can't order this thing. We are not going to need it. I saved the department 92 million. That could have used to buy cameras that were never going to be used. Beyond me, remember I say I signed and approved that the independent assessment must be done based on the advice of National Treasury also. Even us as forensic services, there is a letter there, 29 April 2016, which is saying, take it for independent assessment and we will pay. In other words, forensic services was even prepared to pay for the independent assessment. To date, it did not happen. Come the 1st of June 2017, I'm out of office. Having directed that you must still do independent assessment, defend the litigation, because at the time there was an email from Atemba saying, we now want these, they were now demanding 14 million to say, because you did not order for our damages to bid and so on, pay us 14 million. I don't know what happened, because since the 1st of June 2017, I'm involved nowhere. They go on, then there is a settlement, which is signed by General Setole to say, let's settle for the no more than 14 million. When I was in office, I saw them asking for 14 million, but they settle to pay 24 million. Now, I don't know how long it took to settle the 24 million, because there is 7 million extra that they paid for interest. Now, Honorable Chair, my question is, I'm not going into the merits of the dismissal or whatever. My question is, what do I have to do with payment that was settled by General Setole in 2018, 2019, when I'm long out of office, despite the fact that everyone consistently in forensic services was opposing and say, we can't pay. No one of forensic services was involved in the litigation, deliberately excluded. And when they pay, after they paid, that's when they come running to me and say, you cost the state 24 million rands loss.
General Paslani, I don't disagree with your narrative. That's why I asked you if we can agree. that whether it's the 92 million or whether it's the 24 million award of Judge Harms, it's about the same contract. Yeah, can we agree then?
Well, if you want me to say it for the sake of saying it, I agree. We can move.
Okay. A reluctant yes, I'll...
It's not
agree with it.
reluctant. I've
No,
already
it's
expressed myself
simple.
there. I
We're getting
agree,
stuck on-
and I have
unnecessarily.
explained the context because the context was wrong.
And the reasons why the arbitrator found your dismissal procedurally and substantively fair are reasons which are not part of the award of Judge Harms of the 24 million. They are completely separate. That is, the 24 million is after there'd been demands made by the successful bidder. It was made clear to them that SAPS made it clear to them we're not going to honor this contract, so what they called repudiated the contract. And at the end of the day, Atembu sued and said, look, these are the damages that we suffered. We also know from the award that at the arbitration, SAPS were not even represented there at the arbitration. They didn't have any witnesses there, and their counsel complained that they didn't have an instruction. And LTC Harms then said, in that case, I'm making the award. Now that is separate from the 92 million. But we're talking about the same contract. Okay? And I accept that that settlement agreement was signed by National Commissioner Satori at the time and had nothing to do with you. Okay? So as far as your dismissal and the reasons for your dismissal are concerned, you've taken that as far as you can so far, and there's a judgment outstanding. The 92 million contract, or at the time the full contract that was before the arbitrator, that related to your let's call it alleged conduct or misconduct in the process of that tender. It didn't, and to put it again also on the record, at that time it didn't involve any dishonesty on your part. The arbitrator found that your conduct was reckless. That is what the arbitrator found. Okay. So can we move on from there? But the contract itself, it does feature later on in this whole narrative for other reasons.
Am
can deal with them.
Am I allowed to
Of
talk?
course.
Paragraph 41. Even the acting judge at the Labour Court found no element of dishonesty that Lieutenant General Reid attributed to me, and the learned judge ought to have found that the commissioner completely ignored or failed to deal with material information placed before her. That's on page 17, paragraph 41. The learned judge also found that my dismissal was procedurally and substantively fair on charge 1, only one charge. With the leave of the Labour Appeal Court, my application for leave to appeal was granted and the appeal was heard on 16 September 2025. To date, we wait for the judgment of the LAC. I'm also awaiting the outcome of an investigation conducted by the Public Protector of South Africa on the complaint I lodged in relation hereto, registered with since 2022. 4 years later, I'm still waiting. So I really have run out of the appetite of dealing with that matter because it's very well covered in my affidavit, and there is no distinction between the Harams award and the contract that was awarded in July 2014 by Supply Chain Management. The payment emanates, which follows Harams' judgment, is on the same 92 million contract, which for record purposes, once again, I had spent no cent on that particular contract.
I accept that in relation to that 92 million rand contract, your view was that the successful bidder should not have been awarded the contract because the product was defective. That's what you said.
Chair, I want to disagree with your view because that is the narrative that has been peddled outside. Your view, it is said, I did not agree with that contract because it was not awarded to FDA. So if you say my view, I disagree. The view of forensic services led by me is that that contract was not compliant and the record speaks for themselves.
Again, General Paslani, let me not be quoted because I'm referring only to judgments that had been handed down. And in your application for leave to appeal, that judgment is also in the bundle. It's in our bundle. Yeah. It's in not in the bundle. In the exhibit bundle. When you applied for leave to appeal, and what page is it? It's item number 6. Where is the but can I refer you to paragraph 26? It's on page 11 of the judgment. You see that? The applicant's conduct did not need to amount to serious insubordination, for it constituted serious misconduct. Regulation 9 sets out serious acts of misconduct to include serious insubordination or similar misconduct. Having considered the evidence, I'm satisfied that the applicant's conduct amounted to similar misconduct and that it constituted serious misconduct. And then later on at paragraph 33, and this is in relation to the 24 million, the LTC Arms award. Although the applicant was not involved in the settlement process, he set in motion the sequence of events that led to the first respondent, breaching the contract with EFG, that's the successful body bidder, and ultimately resulted in EFG having a claim for breach of contract against the first respondent. This ultimately resulted in the first respondent paying EFG an amount of 24,494,000. Again, that's what I'm reading to you. That's what the judge found.
Judge who?
Sorry?
Judge?
Judge Davey. Acting Judge Davey.
Chair, ordinarily, I will not want to dignify what that judge wrote there out of respect for the judiciary. Because if this was to be correct, it is me who on the 22nd of October 2014 sent supply chain management in response that you have awarded a contract to a bidder whose product doesn't meet the specifications. Let me It is me on the 4th of November that I write again to supply chain management after I called the two. Maybe you will tell me when you are to listen to me. Chair, I'm responding to questions. I suspect that I'm to be listened to by the person who asks questions. It's me who in November 2014 that I respond to supply chain management. After I called the service providers, that is Atemba and FDA, to come and demonstrate the capability of their cameras. I'm not alone. I'm with management of forensic services. That presentation satisfied me that the response I got from the experts, which said the camera doesn't meet the specifications, then gets demonstrated to me on the 28th of October 2014 by the same service provider, Atemba. And I saw it with my naked eye, the stitching and the non-compliance which is happening. On the 10th of March 2015, I write to supply chain management a comprehensive letter, which is say, please subject this product to an independent assessment. On the 29th of April 2016, the divisional commissioner acting writes to supply chain management and say, this product doesn't meet the specifications, therefore we can't buy. We even make an offer in that letter to say, subject this thing to an independent assessment and we'll pay. 29th of September 2016, National Treasury responds and say to supply chain management, subject this thing to an independent assessment with CSIR and what is it, South African Bureau of Standards. 23 November 2016, in my capacity as an acting national commissioner, I approve and say, subject this thing to an independent assessment. It's not me who wrote, it's supply chain management after they receive the National Treasury letter. And then I later leave. Was it only going to be satisfactory if we have ordered? So this judge who's writing here, must I respond? Was it going to be acceptable for us to have spent 92 million on a non-compliant contract? I will be dancing a different tune today. It will not only have been this concocted disciplinary, I'll be parading before the courts to say corruption, corruption. If I said to my people, buy, they are telling me they are experts. I'm not an expert. They are saying we are not going to be able to use this thing. Now, consistently, you are being told, buy, buy, buy. Just now, there is a discussion on the 360. I don't know why is it also 360. 360 million of, what is it, Medicare 24, the Mr. Ket Matlala's contract. Why is that contract cancelled so shortly after the allegations that it doesn't meet the specifications? Why is this 92 million rands not cancelled, despite us, the experts, say that camera we are not going to be able to use? Is it not supposed to follow the same process? There is clause number 2.7 of the general conditions of contract management, which tells you what process must be followed once there is an issue. So, Chair, I see, I can't help you. I'm not going to dignify this judge's comments with a response. That's why they are before the Labour Appeals Court. Let's wait for the Labour Appeals Court to pronounce. I'm not going to spend my energy on that person.
Can we please take Honorable James? There is a microphone there. The microphone behind you is on. If you can please help to switch it off. Thank you so much.
Thank you. Apologies. Thank you so much, Chair. I wanted to ask this question almost 5 minutes ago already. General Patlani, you make mention that you wrote to supply chain management, you wrote to National Treasury. Now, like we've said previously to the witnesses that appeared before this committee, here when we say we wrote to, we want names. So we really need you to mention the names of the people that you wrote to that ignored those letters. Thank you.
Honorable Nomvalo.
Yeah, no, thanks, Chair. It's a follow-up question. I just want to establish if I have the correct understanding of what the General has said. Do I understand you, General, to be saying, when you said they must subject the product to an independent assessor, do I understand you to be saying you wanted them to make an assessment of whether the product does meet the specification or not? Do I understand you correctly?
That is correct, Honorable Chair. I did not want, because remember, one, this complaint is informed by a complaint that is lodged by a competing service provider being FDA. Now they complain about a product of a timber. I take that complaint, which did not come to me. It went to supply chain management, the right place where it's supposed to be. They now send it to me. What I did is to put together my experts. Remember, those specifications that they used to publish the bid were developed by the end user, the experts, because they know what is it that they want. So I now bring them together and say, there is a complaint. Can you please assess and come back to me? They then respond to me with an information to say, indeed, we have found that this contract or this bid, this camera, which is now on offer, it will not meet this it doesn't meet these specifications. Based on that, I write to the Divisional Commissioner, Supply Chain Management. It's my letter dated, I think, the 22nd of October, which is here on file. Now, once that happened, there were meetings, including me and the Divisional Commissioner, Supply Chain Management, to raise this issue. But surprisingly, I was getting letters from the same supply chain management saying, place orders, place orders, place orders. And my question is, why do I get this? So ultimately, 29 April.
I'm sorry, Chair. So ultimately, the independent assessment was made.
No, to date, it's not made because National Treasury, like I mentioned, was the last authority to respond to supply chain management and say, subject those cameras to an independent assessment. Now, the same supply chain management and legal services write to me. Now, then I'm the acting national commissioner to say, can we subject it to an independent assessment? Of course, I said, yes, let's proceed. To date, that independent assessment is not done. So it was to determine, someone independent must tell whether what we are saying as forensic services, whether what the suppliers are saying is correct. But to date, it's not done.
I'm satisfied, Chair. Thank you.
Honorable James, are you satisfied?
No, we still don't have the names. Thank you.
Chair, I'm using a document which is full of pages. Can I just look? But I know that my letters were all directed to the Divisional Commissioner Supply Chain Management. At the time, the Divisional Commissioner Supply Chain Management was General Cruze. I think
what we should do when we break at 5, you can look for those names and make them available.
Yeah, but it's easy, Chair.
Unless if it's very easy for you to find them now.
Yeah, if you look at annexure JKP4. Now, JKP4, it's the information note that I have approved. Sorry. What is 201? Page 201. Oh, okay. Yeah, and then I'm just going to give the numbers, then we can find the pages. There is an extra JKP 5. We will see its correspondence by a Brigadier Kruger. And you'll see at the bottom of that, he's writing, say, I refer to the telephonic discussion this morning. Kindly find attached the approved information note from the National Commissioner's Office for your attention. The instruction is that you proceed with facilitating the appointment of independent expert assessors. This process will take place while we defend the summons. That is JKP and then JKP 5. And then now I was referring earlier to a site visit, the BEC. After they've done their own evaluation on site, that is on JKP 6. And you'll see page 2 thereof. It talks about what the non-compliances were of this particular camera, especially in respect of a timber. And the next one is on, and then JKP 9. On JKP 9 is my first letter, the one that Honorable James I'm referring to, that I wrote to Supply Chain Management. It's on JKP 9. And then you also look at that in relation to JKP 10. That JKP 10 is a response from within Supply Chain Management. The chairperson of the BAEC, who's now saying they have made unfortunately, they say they did not have technical experts on the bid adjudication committee. That's why, that will explain why at the end of the day, it was approved. And then my last letter as the Divisional Commissioner Forensic Services, there it is, JKP 11. I wrote on the 10th of March, 2015. And you'll see my last sentence there. Based on the above explanation, the Division Forensic Services does not support the decision made by the Bid Adjudication Committee to award the contract to Etemba. It's 249, this same, yeah. On page 249, I'm told. 249, yes. I hope I've answered a few of those questions in terms of the correspondence that was there. I think in JKP 15, and this is now in relation to the Aranse Award, not Aranse, Haramse Award. There is on JKP 15, 259, okay? The acting Divisional Commissioner of Forensic Services, I'm long gone, because this was 2018-0702, General Magadlela. Right here, it remains a challenge for me to clarify if equipment that does not meet specifications proceed to enjoy approval from the bid. So he's simply agreeing. I mean, this is in 2018. I'm long gone, but he agrees. And then the National Commissioner on the 2018-0704 approves the same thing. While he's been told, you can't approve this because the thing is not compliant. But there it is, it's approved. But then it becomes my problem. I don't know how. I hope I answered the question, Chair, in respect of some of the correspondence. Those that I did not find, I'll find them during a little bit later and share.
I'm covered. Thank you so much, Chair.
Advocate Aransa, we can proceed.
Well, Pashlani, I'm afraid you're misleading this committee. Let me demonstrate this to you because you're making an issue of it. I thought we'd move on. Can you look at, firstly, when you indicated that you wanted or you were in support of the appointment of independent expert assessors, that was only in November 2016. And in November 2016, you were now the acting National Commissioner. Is that right?
Chair, I'm allowed to take offense.
Can I
go
what I'm
with
trying
you?
to demonstrate?
That is my first correspondence as the acting National Commissioner. My only correspondence. I've just shown you, Council, 10th of March 2015. That is the last letter that I've written as the Divisional Commissioner of Forensic Services. And I've shown you the letter dated 22nd of October 2014.
If with reference to your annexure JKP 4, which is at 201. Let's start there.
Chair, I'm also human. I suspect I'm allowed to take offense. I can't be told that I'm misleading when I am tendering here factual information. And I'm going back.
Allow me to complete
Okay.
what I want to put to you. I don't make a statement like that lightly. As counsel, as an advocate, subject to the rules of ethics, I can't make a statement like that. You're correct, that you must lead without reference to the facts. And that's not what I intend to do. Because you've given your narrative and I'm saying it's misleading and it distorts the facts.
Yeah, I'm listening.
Are you listening?
I'm listening, sir.
Now, the losing bidder, FDA, lodged the complaint on the 22nd of August 2014
Correct.
about Itemba's conduct.
Correct.
You, and at that time, of course, you were still the head of forensics.
Not the head, the Divisional Commissioner for Forensic Services.
Divisional commission, the divisional head of forensics. And you, when they lodged a complaint, you signed it on the 22nd of October 2014.
Sorry, just I signed.
This complaint. Yeah. Your own complaint was signed on the 22nd of October 2014. SCM wrote a letter on the 4th of November 2014 to the Bid Evaluation Committee to reconvene to obtain clarity from the nominated expert on the BEC panel on the product of Itemba. The BEC then reconvened and provided a report confirming that both bidders, Itemba and FTA, complied and they submitted their report. So this is all in 2014. On the 10th of March 2015, Forensics wrote a further letter in relation to the issues of the Itemba product. And on the 31st of March 2015, The concerns were addressed to Itemba in a letter, and on the 7th of May 2015, Itemba responded to the concerns raised by forensics. On the 13th of May 2015, Itemba's letter was forwarded to forensics for comment and information. On the 4th of June 2015, you now as head of forensics noted that the matter is urgent, but however undertook to provide a detailed response, and to quote you at paragraph 2.29 of your response of 4th of June 2015, and that is in the information note JKP 14, you provide a detailed response, quote, at an opportune moment. So that's on the 4th of June 2015. On the 27th of July 2015, a reminder was sent to you awaiting your response. No response. On the 2nd of October 2015, a further reminder was sent to you to respond to Itemba. No response. That's the whole of 2015. On the 10th of February 2016, Itemba sent a letter, a follow-up letter, detailing the products offered, the benefits of the product offered by them, and requested that an official order be placed. Because the tender award had been made. They were entitled to receive orders in accordance with the award and the contract that was signed. On the 29th of March, Itemba, not having received any orders, issued a letter of demand. On the 25th of April 2016, Itemba requested a meeting with the Forensics Division. Only on the 29th of April 2016 did you, through Forensics, reiterate the viewpoint about the Itemba product that it was defective. Itemba then says, look, you are repudiating, your conduct is repudiatory, and we are now cancelling the contract. On the 14th of July 2016, Itemba accepted the repudiation and cancelled the agreement. Yeah. And that narrative is the same narrative that is recorded by the arbitrator in her award. And the reason why the arbitrator found against you is that in the context of this matter, and given the delays and the non-responsiveness on your part, she found your conduct to be reckless. Now, this morning already, I said to you, the arbitrator didn't find that you were dishonest, but you were reckless in your conduct. Can we agree on that? That would not agree that it was. You don't have to agree with me that it was reckless, but to agree with me, that is what the arbitrator found. So, if you also look at page 213 of this JKP4, right? It relates to clause 7 of the general conditions of contract, which places an obligation on the parties to make an attempt to resolve issues amicably by mutual consultation.
What page did you say?
Page 213.
213.
These provisions, I put it to you, had been blatantly disregarded. There were attempts, the bid evaluation committee and the nominated experts and supply chain management and Itemba had made attempts to engage and to put their concerns to forensics, but these attempts were either disregarded or ignored. And that's the basis of the arbitration award, which still remains undisturbed.
It remains?
And when you say
No. There is a word you used. It remains
undisturbed,
undisturbed.
yes, it hasn't
Okay.
been set aside yet. That's what
All right, fine.
yeah. So, I put it to you that this reference to I think it's JPK 5, the one on page 219 of 28 November 2016, is a complete afterthought. It was belatedly sent after the contract had already been cancelled.
Which one? Which letter are you referring to? JKP?
JKP 5.
Okay. A complete afterthought.
This is the one where it's from Lawrence Kruger, Brigadier, dated 28 November 2016. It's to Mokoena, Lieutenant General, the subject matter, appointment of expert assessors, Itemba Group. Dear Lieutenant General Mokoena, please see the trailing email by Major General Mnisi, Legal and Policy, as well as the attached information note signed by the Acting National Commissioner, that's yourself, to approach an independent third party for an expert assessment as to whether the product offered by Itemba Forensic Group complies with the specification. General's respectful approval is requested to proceed with the referral of this matter to the Office of Major General Pillay to activate the procurement process for the appointment of an independent expert as mandated by the Acting National Commissioner. So that is the narrative in its proper context. And it's in that context that the arbitrator found against you.
Am I allowed to respond?
Of course,
Okay.
if I may just round this off, you also know that you were present initially when Itemba's expert, I think a Professor Weiss, WEISS, he came here from Germany because he's the what do you call it, founder of this camera, of the camera device. Yeah. He came and you were in that meeting with all the senior management, and he made a presentation where he in fact said that this camera is not defective and that it does comply with the specifications, and he then undertook to ensure that maintenance on this camera is done on a regular basis as required by the contract.
Am I allowed to respond?
Now the reference to Weiss's evidence is made also in the arbitration award. And this is in JKP 10 at the bottom of page 247. The bid evaluation committee, Brigadier Magagula, chairperson of the Bid Evaluation Committee, on the 20th of November 2014, they recommended that the issues raised by forensic data analysts in their complaint were not found to be part of the bid specification, can therefore not be considered for the cancellation of the contract. However, an agreement was reached that the matter should be referred to legal services for advice and proper guidance. It's at page 247. Annexure JKP10 is 246, and it's an information note. That's addressed to the Divisional Commissioner at the time of Supply Chain Management, Lieutenant General Cruiser.
Am I allowed to respond now?
Yes, of course.
Chair, I'm asking.
You don't need my permission. I have put to you what I wanted to put to you, and you can now respond.
I will never say to an older person you are misleading because of how I'm brought up. Worse, I can't say it to counsel. But I seriously take offense when such is attributed to me. And I'm presenting here factual information. Page 213 that councillors referred to, 2.27.1. If any dispute or difference of any kind whatsoever arises between the purchaser and the supplier in connection with or arising out of the contract, the parties shall make every effort to resolve amicably such dispute or difference by mutual consultation. For everyone's information, I am not a party to the contract. I did not sign any contract with anyone. The contract is between Supply Chain Management on behalf of the South African Police Service and Atemba. 27.2. If after 30 days the parties have failed to resolve their dispute or difference by such mutual consultation, then either the purchaser or the supplier may give notice to the other party of his intention to commence with mediation. No mediation in respect of this matter may be commenced unless such notice is given to the other party. Anyone who have seen a notice in compliance with provision 27.2 of the general contract must tender it with me. Should it not be possible to settle a dispute by means of mediation, it may be settled in the South African Court of Law. Mediation proceedings shall be conducted in accordance with the rules of procedure specified in the SCC. That is on page 213. I just want to check what the annexure is this. Is JKP? No, is it not JKP3? On top there, that information note starts on page 191, and that's JKP3. It's JKP3. And then this is the same information note that I approve on the 23rd of November 2016. What was I approving? Paragraph 3, because this is submitted to me by Supply Chain Management. So it's a paragraph 5.3. 5.3 reads, in view of Atemba, it's on 215, in view of Atemba's statement that they will proceed to serve sermons and claim damages suffered as a result of the service breach of the contract. And the risks involved in the service approaching court with an application to set aside the defective decision. it is recommended that the service awaits the serving of summons by a timber in this matter and defend it. I'm taking cue. This information note is put together by a learned colleague, Lieutenant General Khan, who is the Divisional Commissioner of Legal and Policy Services. Now, I said 5.3, that's what I was asked to approve. And that's what is sitting before me. 5.4, which is the second thing that I'm being asked to approve. It is further recommended that National Treasury, Office of the Chief Procurement Officer's proposal for an independent expert assessment as to whether the product offered by a timber complies with the specification should be pursued, as this will remain relevant in this matter. So it is following this information note that the email, there was an email referred to of Brigadier Kruger, page 219. Yeah, maybe I'm not staying here. Page 219. And you will note in that email, it is not directed at me. After they received my approval, which they requested, they then communicate to 219. Now, Kruger sent it to the Divisional Commissioner. That's the Divisional Commissioner of Supply Chain Management, the custodian of contracts at the time. He said to me, please see the trailing email by Major General Munisi. Major General Munisi used to be in legal services, legal support, as well as the attached information note signed by the acting National Commissioner to approach an independent third party for an expert assessment as to whether the product offered by a timber forensic group complies with the specification. General's respectful approval. He's not asking my approval. I've already granted approval on what they were asking. Approval to proceed with the referral on this matter to the Office of Major General Pillay, blah, blah. And then I read earlier the bottom part of that. You can see nowhere in that thing am I addressed. It's General Khan, who was the Divisional Commissioner Legal or Head of Legal, General Mukwena, who's the Head of Procurement or the Divisional Commissioner Procurement, Major General Mangale, who's the Component Head, Crime Scene Management. In other words, it is in his environment where those cameras were going to be used. Groenewald used to be in legal and so on. But it says the instruction is that you proceed with facilitating the appointment of an independent assessment. This process will take place whilst we defend the summons. Whether it's the judge or the arbitrator, someone must show me in the contract that was signed to say, once the contract was signed on the 28th of July 2014, you must order within a month or within 2 months or 6 months. This contract made provision for the first order of 60 cameras in the first year of the contract, because it's 2 years, it's over 2 years. Which means if you take from July 2014, by July 2015, that's the first year within which there was an obligation to order 60 cameras. But before we could even place an order, it is already found that the contract did not comply with the specifications, that the cameras that were offered by the bidder were never going to be used. Now, I received a letter from Supply Chain Management, the one that we're referring to from FDA, which came to me through Supply Chain Management, is JKP 8. That letter of the Divisional Commissioner Supply Chain Management it's dated 2014-0904. Yeah. 2014-0904 coming to me. Now, somebody who is a judge or an arbitrator somewhere is saying, why did you not order before the complaint? What was the rush? Was I supposed to order just because there is a contract? We always get asked the question of due diligence. So, thankfully, the complaint came and I was able to send it to the experts in the environment. That's my letter of the 22nd of October. Let me go to that. There is my letter of the 22nd of October. That's why, Chair, it can never be an afterthought. In this letter, I communicate paragraph 2, which is JKP 9, on page 244. It is alleged in the inquiry that the product of the successful bidder doesn't comply with several criteria as stipulated in the bid specifications. Paragraph 3, it says, the bid evaluation committee shortlisted 2 bidders from the companies, namely Atemba and for FDA. Both bidders indicated that their products comply with the bid specification. The shortlisted companies were subjected to further evaluation, which included supplier site visit and product demonstration. It was not apparent to the bid evaluation committee that the bid offer from Atemba Forensic Group may not be compliant to any of the specifications. On paragraph 4, we are telling supply chain management, our findings are that subsequent to the awarding of the bid, receiving the inquiry, it is found that the bid offer of forensic Atemba Forensic is not compliant to the following critical specification. Underline critical specification. Clause 3.5.1, the specification required the spherical camera that rotate, capture, and capable of scanning and also create a full panoramic image during one single rotation by turning on motorized rotation device. Now, there we are saying the product of Atemba does not provide one single rotation scan, but rather rotates and then scans a limited view, repeating this process several times and requires stitching by the user to provide a panoramic image. I can go on. Those are the reasons advanced in the letter that is communicated to supply chain management. Now, Council mentioned JKP4 of JKP10, sorry. That is the letter from within supply chain management. This person who's writing this letter is the chairperson of the bid adjudication committee in supply chain management. And this submission of hers, it's prompted by my submission. There it is. To give feedback to the divisional commissioner on the outcome of a meeting held. The letter with reference blurb dated 2014 was received from the divisional commissioner supply chain management to reconvene and discuss the complaint received from divisional commissioner forensic services on behalf of forensic data analysis company. Exactly. Here it is. I'm complaining on behalf of FDA. FDA lodged a complaint with supply chain management. It is supply chain management that submits a complaint to me and say, can you input? Can you look at it? I respond. But no, it's a complaint because even in the records that the council is reading of the arbitration, somewhere you will see they received a complaint from me. I never complained. We responded to a complaint. But important, if we were to take the honorable members into confidence, page 247, findings of this particular bid adjudication committee.
Evaluation.
That is bid
Bid evaluation.
bid evaluation committee. Thanks, Council. In the light of the above facts, the following findings were made. Now, after reading them, whoever is confused, maybe I'm confused with. If they are not confused, I'm also not confused. It says, the technical experts were part and parcel of the committee who agreed that both bidders met all requirements during the evaluation and site visits. Now, this is what I was referring to. Nobody took the responsibility of leaking confidential information to forensic data analysis as contained in their complaint. Thirdly, it says the technical experts indicated that their representatives who visited both bidders' sites were not competent enough to make informed decisions after the visits. It's them, it's not me. They are saying they were not competent. The reason why they were not competent is because a nominee of forensic services who was an expert, a crime scene expert, was excluded from participating in the evaluation. So this bid was evaluated by non-experts, and the Treasury regulations demands that when there is an evaluation, there must be an expert. The final recommendations of the panel did not highlight the concerns raised in the complaint received from their division. Now it's again their division. They were only highlighted as pros and cons. Now, those pros and cons, it's exactly the non-compliance issues that are being raised. Now, my letter of 2015-03-10, I was still in the office as the divisional commissioner. I've already mentioned paragraph 14 of that letter, 252. Based on the above explanation, the Division Forensic Services does not support the decision made by the Bid Adjudication Committee to award the contract to a Timber Forensic Group. If you go and look at paragraph 11 on top, it says, forensic services cannot be placed at risk and under no circumstances will the expert status of crime experts be compromised. So, Chair, if this is an afterthought, it is an afterthought. 2016, the letter you are referring to of 2016, I am long no more the Divisional Commissioner of Forensic Services. There is an acting Divisional Commissioner because I left the environment on the 14th of October 2015. And in this letter, the general who wrote the letter, paragraph 7, it's on page 256. On the 6th of August 2015, a further meeting between Lieutenant General Patlani, Lieutenant General Cruze, and other members from Division Forensic Services and your office were held. During this meeting, the concerns as raised above in terms of compliance of this item to the bid specification was again discussed. When that discussion was taking place, I am still the Divisional Commissioner Forensic Services. And I convened this meeting with General Cruiser to go and discuss this thing because we are saying, can we just be helped? We are not going to buy from this thing until such time that the issues are resolved. It is following that letter of 2016-04-29 that Supply Chain Management wrote a letter to National Treasury. And there is National Treasury, JKP 14, 29 September 2016. So, Chair, I'm not sure in which way am I misleading. What I can tell, and I will tell it until I die, I will never spend public funds on something that is not going to be used, especially 92 million go down the drain just because there is a glorified service provider somewhere who has been given a contract and I must append my signature and say, place an order. I will never do that.
So again, I'm not going to debate this with you any further. I'm not here to provide the answers, but this is the way, all that what you said now, this is how the arbitrator has dealt with it and subsequently confirmed on review in the Labour Court. And I'm looking at the award. It is item 4, dated the 18th of the 16th of July 2021, from paragraph 81. The applicant's conduct, in my view, was reckless at this stage. There was a threatened legal action. The applicant, that's yourself, held the view that supply chain was insistent on this procurement despite the alleged non-compliance. He, however, failed to see that it was him or his division that were making it difficult for supply chain to act appropriately in this matter. It is not sufficient for him to merely indicate that the equipment was not compliant and not comment on the report that indicates that, in fact, the equipment is compliant. What compounds the matter is the fact that the inventor, that's Dr. Weiss, of both these cameras, was the person who was providing the opinion on the effectiveness and compliance of both. The evidence of Dr. Weiss, which of course was not contested in the arbitration, you were entitled to contest his evidence, that he was the inventor of both and understood how both these cameras worked, was not disputed or challenged. On the 2nd of October 2015, another letter from Supply Chain Division was sent to the applicant referring to the previous correspondence where a request was made for comment. And it was indicated that this was required in order to assist supply chain to finalize the matter. Because you're the end user, you must use it. The applicant in his testimony indicated that he did not respond to this email and said that, quote, he could not grace this with a response. Again, I find the applicant's attitude to be grossly reckless and a clear dereliction of his duties. Despite the applicant's views on the compliance or non-compliance of the equipment of Itemba, there was a contract that was concluded between this entity and the respondent. The applicant indicated that the contract was worth 92 million and that he was not going to procure and spend that kind of money if that was going to not benefit the respondent. But unfortunately, by failing to assist supply chain in this regard, he was actually putting the respondent at risk of being litigated against and not even having any way of defending itself. During his testimony, General Pashlani emphasized the fact that he was not in supply chain and he didn't understand why he was dragged into the contract engagement. So the arbitrator took into account exactly what you have told the committee, that it's not you, but it's supply chain. Well, it is so that contract management falls squarely within the domain of supply chain. The facts must be considered in the context of the prevailing circumstances at the time. The prevailing circumstances were that the respondent, through supply chain, concluded a contract with Itemba, and the end user, led by the applicant, was saying that the procured product was not compliant. Itemba provided a report that addressed the concern raised by the end user. Supply chain was simply saying to the applicant and or the division to provide your comments on the report to assist in determining the way forward. The applicant indicated that the reason why he could not, quote unquote, grace the correspondence from supply chain with the response was because already in August 2015, there was a meeting that he held with the Divisional Commissioner, Supply Chain, and that in this meeting, he had indicated that supply chain must get an independent expert to provide advice on the suitability of the product of Itemba. The challenge with this version is that it is not corroborated. On the documentation presented in the hearing, it appears that there was a meeting, but there was no minute of this meeting. Further to this issue was discussed at the meeting, testified by the applicant. I cannot understand why he could not just respond to the division, to supply chain, and tell them that he had already discussed the issue with Cruiser and it was agreed that an independent expert be appointed. The applicant did not provide any response, and I find by failing to provide the response to the report of Dr. Visa, he put supply chain in a difficult position as they could not just take a decision to cancel a contract without further information from the Forensic Services Division. So that is how what I had read back to you based on the information note and your narrative. This is now the concluding remarks of an arbitrator who conducted a hearing, witnesses testified, you testified, and this is what he concludes at paragraph 98 of the award. On the totality of the evidence, I find that the respondent has proved on a balance of probabilities that the applicant intentionally caused the non-compliance in respect of contract 19/1/9/1/187 for the purchase of 360-degree panoramic cameras. I, with respect, General Paslani, I think you've given your view and you've indicated why you don't agree. I rely on the documents I have in front of me, the arbitration award that has now been taken unsuccessfully on review to the Labour Court. I don't see why or how any further discussion or debate on this issue is going to assist the Honourable Committee. I think your views have been made known pretty strongly, and they will obviously take that into account.
Chair, may I say the last thing? Let me just stick to the fact. Reference is made here to Dr. Weiss, and these honorable members and our beloved country is being told that I'm supposed to believe Dr. Weiss, a German, who is a service provider, Atemba is buying the cameras that he was selling to us from Weiss. So Atemba is a local supplier. Weiss is an overseas manufacturer of this so-called 360, the Civita that you are talking of. Weiss happens to have worked for the company that manufactured Speron, the 360 camera that we as the South African Police Service have deployed successfully. So that 360 camera, the Speron, actually assisted us immensely in the Oscar Pistorius case. That's the first big case where that camera was being used. Weiss happened to have left Speron having stolen the intellectual property of Speron, and he went to establish his own Civita camera. And he now sells it to us through Atemba. Now, when you say I had a meeting with him, it was me, I refer to it in my testimony, that on the 28th of October 2014, after my letter of the 22nd of October 2014, I called both Atemba and FDA to come and demonstrate their cameras so that we can have a closer look. What is the capability of these cameras? Because this local supplier, Atemba, was just a middleman. They were not able to demonstrate that particular camera. They brought the German Dr. Weiss to my meeting. I never invited Weiss. I invited the suppliers who were bidding. I have invited Timber because they were awarded the contract. Now, whether it's the judge, whether it is the arbitrator, now I hear today, I'm supposed to have believed what Dr. Weiss is saying. How do I believe one supplier while the rules of the game say an independent assessment? It's Treasury regulations that say subject this to an independent assessment. And I'm saying it here today. To date, it's not done. Once again, if I have to suffer because of not having listened to a German person called Dr. Weiss, let it be. I will never spend a single cent on buying something that is not going to be useful for forensic services. And consistently so, my colleagues have said so. Now, Chair, I thought we moved long away from the so-called dismissal. I have traversed that issue. I thought I'm talking about the Spheron. There was, for long I've been saying paragraph E, but at least I have spoken to those issues that are covered on paragraph E, which is until paragraph 81 on the sale. And if we were true to each other, Chair, I'm going to use just two paragraphs. Paragraph 79, it's on page 31 of the affidavit.
Before we go there, can we take Honorable Skosan?
Thank you, Chair. I just wanted to, I was a bit confused as well that I thought the matter of the submission which was given to General Patlana this morning, the issue of the arbitration, those matters, the matter of labor court, because I thought that General Patlana said to us that the matter is in the appeal store, if I remember well. Now, I'm not sure, are we back to that again, what the evidence leader was reading now? We are back to that, or it's a different story altogether? And my follow-up question to General Patlane is, are you saying that if I want to understand, I'm not putting aspersions on that. Is Dr. Weiss, in your view, conflicted in this matter? Thank you, Chair.
Chair, he is definitely conflicted because one, he worked for Spheron, which is the camera that FDA was selling. There, he was fired at Spheron. Then he left and went to establish a company of his own to manufacture Cevita camera, which allegedly is an improvement from Spheron, but I can't vouch for that. So now he is the one, in actual fact, he's the one who's selling. But then even in the council reads here what comes from the arbitration award. I'm told I'm supposed, because he gave an opinion, I was supposed to say, I'm satisfied. Let's proceed with the order. A conflicted person is the one person. He actually is the one who is selling through a timber to us. Now, I must disregard the prescripts. I must disregard what the experts are saying and say, because Dr. Weiss has spoken, let's carry on and spend the 24 million. Now, the council reads, and I don't know why I'm back there, but anyway, I'm just a witness to be asked questions. My duty is to answer. I must not ask questions. He reads out the arbitration award, and we were able to prove that that award relied not on the correct recordings of the proceedings. Because somewhere, for example, in the award, they say, Patlani did absolutely nothing. If I did nothing, what are all these correspondences? And my job was not to answer documents of saying order, order. My job is to make sure that there is a product, and I'm being mistaken for being an end user. I was hearing counsel saying so. End user are crime scene experts. I just happen to be a manager of experts in the South African Police Service. So I take cue from what they are saying. I don't impose things. Whoever wanted the 92 million, unfortunately, they did not get it. But Setola gave them 31 million. I think they are smiling. They did not even deliver a single camera. And then it is me. But this matter is before the Labour Appeals Court. I don't know why I must be going through it. I had it in my affidavit to give background to what has been happening in this regard. Thank you, Chair.
Yeah, Honorable Skosan.
Thank you, Chair. I think the clarity from General is very clear. 24 million plus interest, 31 million was paid without any camera delivered to South African Police Service. Whether the judge said so or the arbitrator said that he found you, whatever, those issues which I don't want to go to. Whether he agreed that you were wrong. But the issue which you are putting to us here is that you saved South Africans. You were saving South African money, not to pay for something which we are not going to use for this country. Those cameras were not even delivered. I think what is important for me, from where I'm sitting, is that it was a fruitless expenditure, Chair. And but thank you.
If I respond, Chair, it's 100% correct.
Before you respond, because this matters go on record, isn't it? So you say that there were cameras that were procured by the SAPS, and those cameras were never delivered. It's not what you are saying.
No, Chair. I'm saying, based on the settlement approved by General Sithole and the payment that was made to Etemba, the payment was for buying the cameras. It is to say, we had the contract, you did not order from us. And the bill started being 14 million, it became 24 million, and then they subsequently paid 31. But I'm saying, for that amount, while it was not an order to buy a camera, there is not even one you can show, but the 31 million is gone.
And who was the person who authorized that payment?
General Sithole and the CFO who was there in Kgosimampuru, they approved the 24 million. They paid the what do you call the plus the 7 million, which became 31 million. And I know they continue to say, no, this matter is dealt with. It is dealt with the AGSA. The person is dismissed. That's the issue that relates to me, not these blue lights that I'm hearing of. I was never.
No, let's not go there. We will come late. We're still on this one. I want to take the following hands. Honorable Breitenbach, Honorable Shongwe and Honorable Ntuli, Honorable Malema. Is your hand up, Honorable Matthijs? The five of you. Honorable Breitenbach.
Thank you, Chair. Chair, with respect, Mr. Paslani is now just, not sure how to put it, talking constantly about prosecuting his own labor-related issues. It's got nothing to do with the terms of reference of this committee. Completely irrelevant to the work we have to do. And I honestly can't see the point of sitting here and listening to it for the rest of the day. I just can't. So either we go back to our terms of reference and deal with issues that are relevant to this committee, or I'm not prepared to sit here and listen to Mr. Paslani prosecute his labor issues in front of this committee. It's irrelevant and we can do nothing about it. Thank you.
Honorable Shongwe.
Thank you, Chair. I think Honorable WDA must understand that Mr. Patlan is led by the SC here on that matter, so either it forms part of TOR or not, but he's led. What I want clarity on, Babu Patlan, is le mali ekhokhiwe ikhokhwe ngoba umthengisi uyakhala ukuthi awuthenganga kithi. And how did they arrive to this amount? What was the formula? What was the determination ukuthi kube so much millions for ukuthi angithenganga kuwe? Two, I think we missed an opportunity CFO Udimpane, but I also second Honorable Nomvalo Magat. Some of these people must come back. Chair, to you, I really want to appeal on behalf of South Africans. Yes, we want to arrest people very urgently. I have a few of them that must be arrested soon. But we can't miss this opportunity of closing this committee because some of these matters, we are on, I think we're still on stage one, if I may call it like that now, of this statement, General Patlan. We haven't even started to go further probing it as the booklet is so big. But I'm hearing that there is a need for iskati esning, Chair. Because I need to understand exactly how do we get to so much millions because that's tenganga kuwe. Thank you, Chair.
Chief Whip.
No, thanks, Chair. My first question is linked to what Honorable Shongwe has raised. And the last one will be a very brief comment in relation to what Honorable Breitenbach is saying. On the matter of the sequence that has been presented to us, just to briefly recap it, a contract is awarded on condition that a number of cameras are going to be ordered within a period of a year. And before you get into the end of that first year of the 2-year contract, certain developments unfold, which include challenging the legitimacy or the appropriateness, relevance, whatever the correct description of the contract. But around the same time or simultaneously, the person who has been awarded a contract is already complaining that you have given me a contract, but we are not placing orders. And I heard your responses to be saying, we are not duty bound to give you orders immediately, because in terms of our contract, we have at least 12 months within which we must order the first consignment of 60 cameras. Now, the question then generally arises in this context. The payment that was then subsequently made, 31 million in total, divided into two, was a payment in compliance, with the grievance that the company launched with the department or with SAPS, in which they were saying, we have a contract with you, but we have not ordered, and yet the year had not ended. That's number one. Number two,
is whether the payments were essentially as a result of a decision arising after 12 months of the appointment without the service provider being given orders to provide the first consignment as the contract was worked out and developed. So I hope you got that question. That's a question I have for you. But then I want to comment on the point that Honorable Bredenbach is raising. I mean, I've been talking to my colleague here next to me, Honorable Sangon, saying to her, I'm not sure, Chairperson, I'm not very certain where are we traveling to, given the extent to which the senior counsel is engaging the witness on the matter at hand. But my own attitude is always to wait a bit before I can intervene, because sometimes you intervene earlier or when you are about to arrive at a destination where you are being led to. But the concern that Honorable Bredenbach is raising is a valid concern. I also have heard that concern, Senior Counsel. I thought we were overdoing this part of the questioning to the witness. But like I'm saying, I thought maybe one should give you a benefit of a doubt. We may be getting closer to where we're going, but I was worried we're taking longer. And I was beginning to talk to Kusela that I'm not sure where exactly are we going to be ending on this aspect. Especially because that's my last point, Chair, and my approach for being long. Especially because where there are contentious matters or there are disputes of facts between what a judge and somebody else, I can't remember the name, has done, and the witness, and we spend a lot of time on that conversation, how does that help us to resolve our own issues as the portfolio committee? So that's an area that I would like our senior counsel to reflect on, consistent with what Honorable Bredenbach was raising. Thanks, Chair. Thanks a lot.
Thank you so much, Honorable Malema.
No, thanks, Chair. I think the Chief Whip dealt with it and the Honorable Bredenbach. If we were to calculate how much we made from 9 until now, working for Parliament, it will not be worth it. You're actually going to eat people's money for nothing. I don't know what we're doing from the morning until now. I don't know what this exercise we're engaged in helps this committee with in relations to the terms of reference. Can we please get somewhere? We need to move, because really we've been keeping quiet, all of us. And some of us, it's unlike us, to allow a situation where we spend a lot of time on a matter that we've been told is actually even before the courts. And you intervened and said you heard that this matter, our awaiting judgment, is on appeal or something like that. Trying to caution the senior counsel on try by means to avoid going deeper into that thing, because a judge will come and say, actually, this is the position. Still, even after that intervention, we're still not making progress. When we break, go and talk to each other and agree on the direction we're going to take. We come back, we proceed as if there was never a break to engage on this matter. So, Chair, please, we need to leave this point. We must leave it and go to issues that are relevant to this committee. Thanks.
Honorable Matthews.
I've been covered now, thank you.
Okay. Can I take your response before I speak on the matter that the honorable members have raised? There are questions that you have been asked, General. Are you able to respond to those questions?
Those that I remember, because they were long, but I'll try. First, maybe I start with Honorable Breitenbach. It's not me who brought the...
Yeah, don't respond to that one.
In actual fact, it's paining me to be taken through the very same thing. which has got inaccuracies, things that I don't agree with, but maybe there is a reason. In respect of what the honorable member duly raised, how or even how they arrived at I think it's Honorable Shongwe, how they arrived at the figures of 24 million, and so it will be found in JKP 16. I was not party to it. I see here there is a memorandum which was drafted to the State Attorney's Office by DP Dupree SC and Botma. On the pages, I think paragraph 4 or so until 6, the figures are there, how they arrived at. But I cannot tell the reasoning behind these particular figures. What I saw before November 2016, the first letter of demand was 14 million. How it escalated from 14 to 24 and now to 31 million, I really don't know. And what Honorable Ntuli asked, remember this payment gets made 2018, 2019. This was a 2-year contract, which means the first year of it would have been 2015 because it was awarded in 2014, July. So 2015 would have been the first year, and then it would have ended in 2016, somewhere there around. And so this was not, the money that was made was not related to any procurement. In other words, there was never an expectation that there is going to be a camera or an item which is going to be delivered. It is the civil claim. I see somewhere here they even say the South African Police Service was not able to justify or bring anything on the table in respect of the quantum. So they basically agreed to what the service provider was offering. And before I forget, there was something that I did not mention when I was responding to counsel on Vase. Vase himself, during the arbitration, if the records are read properly, he considered that he saw in the correspondence that the South African Police Service has expressed the need to have the product subjected to an independent assessment. And in his own testimony, he said, I agree that was the right thing to do. He even said this could have been done by approaching universities or institutions. In our case, we know which institutions were dictated by National Treasury, being SABS and CSIR. But to date, it was not done. So simply put, that was what was supposed to be the case. Yeah, I don't think, is there a question I missed?
By Honorable Shongwe.
It's responded to that question. Okay, thank you, Chair.
Okay. The honorable members are right on the point that they emphasize, and we have not said it once in the proceedings. We said it many times that General Patlan, we are not a dispute resolution forum, and we are not in a review process. The facts were stated very early in the proceedings that these matters are before the Labour Appeals Court. And it was even before we took the lunch break that I said, if there are any matters that are related to our terms of reference, which we can take out of the court proceedings, let us be alerted to those matters. And look, the matter only comes now that there has been a transaction that is suspected of financial improprieties, where an amount of about 31 million has been paid. If, for instance, when this matter was presented for the first time to say, we will not focus on the processes that are before court, but the committee must take note that there is this transaction which has happened, and we think that this was improper because the state lost money, whether it was a corrupt transaction, unlawful, or unreasonable, in whatever way that transaction may be described. It is brought to the attention of the committee to probe it. And the rest of the matters that are before court, we leave them for the court. It's not for us here to justify whatever award the court would have arrived at or whatever judgment the Labour Court would have arrived at. We can arrive at the appeals court and it overturns those decisions that have been previously taken. In fact, we have instances where we had even the Constitutional Court itself condemning not only the judgments, but the conduct of judges who made those judgments. So if we can have focus, and I must apologize, Honorable Breitenbach, because immediately when we started after lunch, you sent a note here to say, but Chairperson is like, we are going off the rail, even when you have warned that we need to focus ourselves to the terms of reference. So can we take up matters that fall within the terms of reference of we no longer want to hear anything about the arbitration award. Look, General Patan, when you live here, if there is an arbitration award or a Labour Court judgment, this committee will not change it. If there is an appeal pending, this committee does not have any influence over that process. We can't influence it in any way. We are going to wait for, like you, for the day that a judgment will be made. And SC, we are appealing for the last time that it is not the purpose of this committee to demonstrate to General Pathani that the judgments or the awards that have been made are right or are wrong. It's not our purpose. Let's look for matters that fall within our terms of reference and deal with them. If there is any, we have said it in many occasions, witnesses that come before us are not accused persons. They are South Africans who come here to have a conversation with us as a committee and help us to probe the allegations that have been made. If there is corruption in the SAPS and there is a witness who has information that helps us to probe those corrupt activities, let's allow that witness to give us a chance. For instance, now, if you have any information about the 31 million that has been paid, and the South African state, you allege that the South African state would have lost money, give us that information. We will deal with it. and make the necessary recommendations on how that matter has to be processed. I think that is adequate, and we should be able to move forward. And honorable members understand that they have given you their time, they have been tolerant, and we must not take advantage that it is still January, we still have other 11 months to come. No, let's focus. Thank you so much.
May I say one thing, Chair?
No, I think I have spoken to you. I have drilled what the honorable members have said. So I'm now handing over back to yourselves to continue with the presentation of evidence. But it must be within the confines of what members have said.
May I proceed, Honourable Chair? General Pashlani, the next item you deal with in your affidavit quite extensively, which is from item F, political interference in the South African Police Service, and you deal with it from paragraphs 82 onwards, 82 to 109. I want to ask you specifically about the allegation that in relation to crime intelligence, the appointment of Richard Ndluli, which is at paragraph 92 of your statement. You allege that the process followed by the late Minister, Nadine Detwa, fell outside of established practice. You allege that the late Minister had failed to present a submission to Cabinet for the appointment of the head of intelligence, which you allege was the practice at the time.
Maybe, Chair, I have difficulty with the word of the use, and you'll have to pardon me. I'm not Lesotho by birth, so English may be escaping me at times. We are on political interference. I'm saying in my affidavit, and before we move to that 84, sitting on paragraph 92, it's sitting on paragraph 84, and I'm going there to answer the specific question. That we must not shy away. Political interference has been prevalent in the South African Police Service, and it became more prevalent following the 2007 Polokwane conference, where many of these things that leads to where you are taking me happened. Because from there on, we started seeing practices that were not the norm. I'm the last person to be appointed following a submission to Cabinet. Everyone else that was appointed after my time, that process did not follow the Cabinet process. And where it started, the post of Divisional Commissioner Crime Intelligence became vacant. That is after the departure of Commissioner Ray Lala. He went to detectives and that post became vacant. General Mpero, Assistant Commissioner Mpero, was acting Divisional Commissioner, Crime Intelligence. And Commissioner Tim Williams was the acting National Commissioner. That's following the departure of the late Commissioner Silebi. I was the Divisional Commissioner, Personnel Services, which means my portfolio related to managing the human resource portfolio of the South African Police Service. That post was advertised, the crime intelligence post, and there was a process followed. First, because there were two phases. There was a recommendation made. That recommendation could not fly, did not go ahead because the new administration came into being. It is there that General Mpero experienced issues, and he subsequently prematurely left SAPS because of issues relating thereto. But the point I'm making there is that it is even in the, if you go and look, I think I made reference to it, to the 2020 protocol of the Department of Public Service and Administration, that when posts at the Deputy Director General level are being filled, the recommendations will be submitted through the minister, the executive authority of a department. It will be submitted to DPSA. DPSA will do the screening and everything that needed to be done. From there, they prepare a memorandum which will serve before Cabinet. And Cabinet will consider those recommendations. And once we have Cabinet approval, it will revert back to the department and an appointment will be made. So in this case, the acting National Commissioner, being Commissioner Williams, was excluded. He called me in, and I had to sit together with the minister and other ministers who constituted the panel. The only official was is the current ambassador. I think is it the UN or Netherlands advocate Wusi? Just can't remember the. Yes, sorry, is it Netherlands? Matonzela. It was Advocate Matonzela. He was the only official that was who formed part of the panel. That panel was chaired by our late minister, and I think there was the Minister of Home Affairs, State Security, and our Deputy Minister initially said only on the shortlisting, but not on the panel itself, the interviewing panel, because I think he had transport issues from Joburg to here. So that recommendation was made. And again, it's not an allegation, it's a fact because it's done by me. A memorandum was put together, submitted to the minister. From the minister, it went to DPSA. In actual fact, it went to DPSA a day before Cabinet was sitting. The morning when Cabinet was going to be sitting, I got a call from the Office of the Minister of Public Service and Administration to say that submission is to be returned so that the appointment can be made. There is no need for it to go to Cabinet. The reason why that position was taken was to say only the president appoints the national commissioner, and the minister later was the one who appointed the head of the Hawks according to the revised act. So that appointment was made without Cabinet approval. and it became the norm since. Now, I was speaking to that issue because, again, when I was listening to the proceedings, somewhere there was reference to you wake up one morning and somebody is a lieutenant general. Or maybe the process that is followed in other departments must be followed. My position is there's absolutely no need to reinvent the wheel. The process is already there. The National Commissioner appoints a panel, chairs the panel. If it is a divisional commissioner, in other words, a lieutenant general at head office, a nominee will be ordinarily the deputy minister of police became a member of the chair. If it is a provincial commissioner's post, the Constitution and the Police Act say a member of the executive council of the province will have a sitting. So ordinarily, the premier will nominate whether it's the MEC or a designate of the provincial executive who sits on that particular panel. And then the recommendations are made and then you follow the same cabinet process. I don't think it's a process that must be, invented. It's already there. It's a question of making sure that there is alignment. And in actual fact, if you look at what we call a national instruction, that national instruction was never changed to factor in, the other provisions that are not consistent with the law. So that's in short on that part of it.
So why and on what basis do you, other than having problem in inverted commas with the process that was followed or the procedure that was followed, why do you put it under the heading of political interference in the South African police? What was Richard Luli not qualified for the position, or is he qualified, or was he qualified for the position?
Okay, let me respond. I don't have a problem. I'm presenting facts here as to what obtains in the South African Police Service. What was the situation before? What is the situation now? And when did that situation change? Even in my affidavit, you will have read, I say, there's absolutely nothing wrong with General Mluli. In actual fact, General Mluli was one of the most competent investigating officers. The Buremach case that was in court, amongst others, was the work of General Mluli with the team when they were in the Northwest. So I can't blame General Mluli for having participated. Like any applicant, he participated in the process. That process was changed, and the decisions were taken. Now, it's a very strange question. Why do I put it under political interference? I'm told the minister's letter is political interference to say operations. It's the minister then was a politician who happens to take over and chair a panel without a national commissioner. That process squarely belongs to a national commissioner of the South African Police Service, not the minister. Only two people are by law to be appointed by politicians, and that politician is the president and the minister in respect of the head of the Hawks. So if it is wrongly placed there, I don't know where it belongs.
No, I'm not telling you. You placed it here. Like
Honorable
we've done
Sangone.
before.
Advocate, may we please take Honorable Sangone?
Thank you very much, Chair. Good afternoon to yourself, honorable members. Thank you for accepting my apology. Good afternoon, General. No, mine was just a clarity seeking issue on the memorandum you sent to DPSA. Can you just explain that who returned the memorandum? Basically, who said, the process has changed, you don't have to go to cabinet? Thank you, Chair.
I'm speaking on a correction because it's long ago, but I think the person who called me was the spokesperson of the Minister of Public Service and Administration. At the time, the minister was Minister Baloi, and what came to me was there was a conversation between the Minister of Public Service and Administration and our former late minister. And I also spoke to the minister because when it came, when that call came, somewhere I was expecting cabinet approval. But then the minister said, no, there were discussions. And following those discussions, this is the position. We can go ahead and announce the appointment.
Chair, not to play, no written instruction. It was just a conversation. Thank you, Chair.
We can proceed, yes, sir.
General Poslani, you put this issue of the appointment of General Mludli under the heading political interference. That's why I'm asking you. I'm not making things up. So, is this, because it sounds to me like it was the case, is or was this an irregular appointment? In other words, some procedure or process, either statutory or by protocol, was that not followed in this case? Or was it a case of an executive authority overreaching and using or abusing that authority to make an appointment for political reasons? Can you clarify that for us?
Chair, that part of an appointment made for political reasons, I'm not going to respond to it because I don't know. All I know, which is what I have already said, was that there is a set process. And that process was the National Commissioner advertises, the National Commissioner appoints a selection panel, the National Commissioner makes a recommendation. Those recommendations are forwarded to DPSA through the Minister of Police. They are being signed off, go to cabinet, come back, an appointment is being made. So I'm not going to dwell into whether it was irregular or unlawful. I'm saying the law, I just said the Constitution say only 2 police people are appointed by the President. First, the National Commissioner. 2, the head of the Hawks. I'm now talking about the South African Police Service. There is no provision for a minister to put together or chair a panel, whereas in this case, you did not have even the National Commissioner. I was not there as a panel member. I was there facilitating the process. So I'm not going to take it further than what it is. All I'm saying is that this is what the law is saying. This is what the rules of the game is saying. And that's why I say I make reference to even the 2020 protocol, DPSA protocol. I think I'm making reference to it somewhere in this affidavit. I'll find it and talk to it later.
Sorry, are you?
Oh, I'm not looking for it now. I'm allowing you. If I find it, I'll come back.
It sounds to me that this, what you are saying under this heading, that this appointment was unprocedural. You said in your evidence that you don't have a particular issue with Richard Nduli, and in fact he's qualified as a police person, police officer.
Well, I don't have issue with General Mdluli. He may not have been in crime intelligence before his appointment, but he was appointed there. He did not appoint himself within crime intelligence. So whoever makes noise about him being the divisional commissioner of crime intelligence, they've got reasons for them making so. But as a fellow colleague, someone that has done work for years, I can't take away anything from him in as far as a manager and an investigating officer or a commander of investigations are concerned. I'm not going to dwell into other things that are being said about him. They are outside my scope. But he's a fellow officer. I actually trained with him when we were on officers' course here in PAL way back in 1993.
There's two reasons why I.
Honorable Sokanyile.
Thank you very much, Chairperson. General, I wanted to check on the issue that you're raising, where the panel was chaired by the minister. That's an anomaly. Then after that, because there are working relations between the head of the administration and the political leader within that department, then the working relations, if you want to have a sound department, there must be those working relations that are sound. Did you raise it with the minister, this anomaly, so that it is not referred to as a precedent? Because it's an anomaly as you are raising it. Did you raise it with the minister, or you simply kept quiet, or the relations were no longer good? They were sour between the minister and yourself.
Honorable Chair, maybe, Honorable Member, let's not make a mistake. I was not the National Commissioner or the Acting National Commissioner at the time. The Acting National Commissioner was Commissioner Tim Williams. I was the head of HR, and I report to the National Commissioner. That is why when he could not sit on the panel and he was not happy with that process, he said to me, just facilitate this process. But as to what deliberations were there between them, I'm sorry, I can't assist.
Management meeting where the heads sit, who never spoke about it.
Management meetings where the heads sit, well, that's why I'm talking about it. It's something that I never kept quiet about it. It's something that we have raised. I was the head of HR, and while I say, and the reason why I was putting this, it's if we say there is political interference today, let's not narrow it and say this is political interference. We can't be selective. It's about how we manage, because what we must understand always is that there's a close relationship between politics and policing, because politicians are governing. When politicians are governing, we as police or administrators, we implement government policy, government decisions. So it's a decision that was taken where it was taken, and we follow suit in terms of implementing. There was really no need to cause hullabaloo in this regard.
Are you fine, Honorable Sakanya? May we proceed? Let's see.
Thank you. The reason why I asked you, General Paslani, is the three. Firstly, you raised the issue of the appointment of Richard Mdluli under the heading of political interference in the context of you, and your words, saluting Lieutenant General Mkhwanazi, by taking the country into his confidence, and saying that the issues raised by him was because of political interference in the administration and operations of the South African police has been prevalent for years, especially post the African National Congress Polokwane Conference. The second reason is that you use at paragraph, at paragraph 92, the second last sentence, you talk about, I encountered, and your words, glaring political interference in this process of filling the vacant post of Divisional Commissioner of Police. And then thirdly, your reference at paragraph 90, where you say that during the tenure of Commissioner Tim Williams, the post of Divisional Commissioner Crime Intelligence became vacant. Assistant Commissioner Mhlangi Mpego, who was for years served in various capacities in crime intelligence, was appointed for over a year as the acting Divisional Commissioner. Crime Intelligence, the vacant post of the Divisional Commissioner Crime Intelligence was advertised. Mpego, together with others, expressed their interest and applied for the post. The candidature and recommendation of Assistant Commissioner Mpego was questioned with some underlying political undertones. The discomfort with the recommendations and candidature of Assistant Commissioner Mpego resulted in the post being withdrawn and re-advertised. So that is the context in which I ask you that question. But today, with respect, we get some sanitized answer that actually, yes, I'm using the word sanitized. And I'm inviting you to expand on your answer, because it seems as if this is a procedural irregularity that the late minister, may his soul rest in peace, had used some other procedure for the appointment of Richard Mdluli.
Chair, I don't know what is sanitized, and this is where I've got some difficulties. I've already, while council started by moving away from the beginning of this F, I took you back there to say, let me take you back and do. So there is no sanitization here. The issues which are in here stands unless we go verbatim on what I've written, which is, I'm glad to talk about. In paragraph, let me first talk about the General Mkhwanazi statement and why I say I salute him. General Mkhwanazi went public on issues which are of national importance. And when he went public, that was not the first time that he's raising those issues. I know he said he was in Parliament, I think on once or twice on the related issues and so on. Nothing happened to those issues until he went on the 6th of July 2025. Here we are. We have got an ad hoc committee. We have got Madlanga. Could it not have happened after the March parliamentary sessions? Even worse, if the National Commissioner did not agree with the decision of the minister, why did we wait until Parliament? Because this is within the ambit or area of responsibility and the mandate and scope of the National Commissioner, where we could have assisted the process by saying, hang on, Minister, I think we are now a step too far in respect of this, if that was the case. So it did not have to wait until March. It did not even have to wait until February. But I'm putting it here. General Mkhwanazi said it before the committee that he had deposed an affidavit. He wanted to go and speak at the Zondo Commission of Inquiry. I'm saying the same here, that I had an affidavit on these issues of McBride, O'Sullivan, and so on. I was called to the Portfolio Committee on Police on the 16th of May 2016. Nkabinde raised these issues thereafter. If you go 16th of May 2016, fast forward, I get to the point where I'm told I must go and sit home. Who addressed the issues that were there? If they were addressed, we'll be talking a different story. Counter investigations and so on flew. So it is on that basis that I'm saying General Mkhwanazi did the right thing by speaking on the issues that are of serious concern. And here we are, we have got the platform at least to address it. If the commission or the inquiry that was recommended by Judge Zondo was in place, maybe these things would have been ventilated there. He is not the only one who would have wanted to go there. These issues would have been raised lately in that platform. Chair, am I talking to myself?
We are here, General.
No, I know you are listening, but
No. You are appearing before the committee. You are not appearing before.
So I must not worry about
You're not appearing before Advocate Arenas.
No, it's fine. I just wanted to hear. I must not worry about their conversation.
No, nobody says you must not worry.
Okay.
What we are saying is that you are not appearing before Advocate Arenas. You are appearing before this committee.
All right. Thank you, Chair.
Yeah. Yeah. Mukhalaka.
And Chair, to be fair to the SC, sometimes when SC ask him questions, he will be busy looking at the documents while the SC is speaking. It happens in this kind of proceedings.
Right.
So we must be patient with each other here. And like you said, it is not the SC's committee, it's our committee. We're listening.
Yeah.
And we're taking everything into consideration. So SC has to be consulting, because if he asks us to adjourn and then he speaks to his colleagues, when are we going to finish? These colleagues of the SC, they're not here for the sake of being here. They need to help him. And when he's paying attention, it looks like he's now being treated unfairly. It's unacceptable what is happening to the SC. Not done.
General Patan. When Advocate Arendse speaks to his colleagues, who are young African female advocates, who in the history of this country never had an opportunity to be at this level. We want male South Africans like yourself to appreciate and marvel at that moment.
For the sake of progress, Chair, I'm here. I'm just a witness. All I'm saying is that
Not for the sake of progress.
no, for my sake.
That national consciousness is what we want.
No, that I agree with, Chair. But I'm saying earlier I was answering a question, and then I could see I was not followed. The same question was being repeated. this thing that I was
No,
talking about.
it's
But
fine.
okay.
It's fine. Listen,
okay.
General, the members of the committee are here.
Okay.
If you listen to what Honorable Malema says, we are here, all of us. And that is why you see from time to time they come in and ask questions for clarity. And there were moments where they also allowed you to move your chair back to get counsel there. And you also said it by your own mouth that I'm speaking to learned people here. So let's have that tolerance. It's our meeting, all of us who are having a conversation with you. And for sure, up until now, you can see that there are no adversarial interactions in this meeting. So let's proceed in that spirit. We are going to break at 17 hours. The next break is at 17 hours. We can proceed. Honorable Breitenbach, turn on the aircon. Okay. Bonani, you heard that. Yeah.
But Chair, you know the air has a tendency of sleeping. Please turn on the air concept before they sleep.
Yeah.
You know the air has a tendency of sleeping at work. So they will sleep if you don't turn on the network.
Listen. No, Breitenbach, wait, let me respond to that. You know, I said this and it's not 10 minutes. I said the year is still very long. We're still in January. Yeah.
Do let me respond. Even when we're asleep, we're better than him.
You still have many weekends coming and many days. We're just on the 14th day of the year. So,
yeah, Chair, Honorable Breitenbach is carrying a very fun object there. Can you check if that is not a grabber?
Honorable Breitenbach, that object is not funny. It's not a funny. He says you are carrying a funny object. Yeah, that is the difference between the young and the old. Advocate Arense. Can I check, are we ready to proceed, or you want me to extend the time of the members?
Thank you. May I proceed, Honorable Chair?
Okay, thank you so much.
Thank you. Also under this heading of political interference, I think we're moving off the issue of Ndudli, and that I think you've given your response to that. You also allege under the heading of political interference the role of by peddling and processing endless and malicious allegations directed towards you and your family. And you say you want to use this opportunity to deal with some of these issues.
Sorry, I see you said this paragraph?
Paragraph 83.
80?
Paragraph 83. It's under item F, political interference.
Yes,
Page 32.
I'm on it.
Yeah.
Just like him, I had submitted an extensive affidavit to the State Capture Commission detailing the capture of IPIT and the egregious onslaught by McBride O'Sullivan and their accomplices. to capture the South African Police Service. Following receipt of my affidavits and consideration of my submission, I was granted leave by the chairperson of the Commission of State Capture for my legal team to cross-examine Mr. McBride, Mr. Matthews Sissoko, and Colonel Rulofse, who implicated me based on falsehoods and fabrications by peddling and processing endless and malicious allegations directed towards me and my family. I'll take the opportunity to deal with some of the issues in an effort to give the ad hoc committee and the public my side of the story. This issue is extensively traversed from page 48 onwards, and it is an issue that even Cedric Ngavinde spoke to this committee on it. So my suggestion, Chair, I'm not here, I was just introducing the issue. The issue is part of paragraph G from 48 onwards. For the sake of not dealing with it haphazardly, I'll suggest that I respond to it when I get there.
So can I draw your attention to paragraph 128, which is on page 38. 58, sorry.
Maybe when we talk numbers, can I just be told which numbers, the bottom or the top? Because
58 is the one at the bottom, is the page number of your affidavit, and 128 is the paragraph.
128, yeah.
Yeah. That was on 14 to 21 May 2017. You were invited with Mr. McBride to a portfolio committee meeting that would deliberate on the alleged interference by the SAPS on IPID investigations into SAPS officials, including you, including me. Well, you. Thank goodness, not me, you. For ease of reference, you annexed JKP 20, which is at 409. 420 of the annexure bundle.
JKP
19 is at 409 and 20 is at 420. This time. Have you got it, General?
I have it.
Complaint by, this is at page 247. Is it two?
No, Chair. For the sake of me not losing it, reference is made to pay JKP 20. Let's deal with JKP 20. JKP 20 are the invitations that I had received. It's emails. The date is, you'll see the middle. It begins with, good day, Colonel, attached, blah, blah, blah. It's from my secretary. And the person who's down there was Colonel Kevin Stein, who was our parliamentary officer. But the bottom line on this is on page 257. That same annexure, I think it's JKP 4, 257. At the bottom of it, it's written there. The Portfolio Committee on Police would like to invite you and the Executive Director to a meeting. Why this was important was that When we were at the portfolio committee, I was accused to be the one who dragged McBride to the portfolio committee. I never asked for McBride to come to the portfolio committee. If IPIT was doing their work, they're allowed to do their work. If they're investigating me, they're allowed to do the investigation.
Let's just get to the committee.
Sorry?
Let's just get to, you are now in the committee, not about who dragged who to the, you would obviously not have been before the portfolio committee if you hadn't been formally invited by the committee to appear. You're now asked to appear jointly with Mr. McBride. So can we just get to that?
But that's where I am. I'm saying, and it's not me who went to JKP 20. I'm saying there where you were reading there is JKP 20, and I'm explaining what JKP 20 is. I was invited to go to the portfolio committee. That's why in 128, the first paragraph, you read about where I was supposed to have been. I was supposed to have undertaken an official trip. It's not me who's reading, it's the council who's reading. And here, I'm now just explaining further to say, there is in JKP 6, the letter from Parliament, which simply say to me, because of your invitation to appear on the 16th of May, you can't be undertaking that official visit. You have to come. And I acceded. But I'm saying to you, we were already in the committee. I'm being accused in that committee to say, I am the one who dragged McBride there.
Now, in that meeting, the complaints by pop crew members and Paul O'Sullivan are referenced. The allegations are the following: irregularity relating to procurement at the forensic division and the oversupply of equipment, centralization of delivery equipment, defective equipment supplied, questions about delivery of equipment by the same service provider to provinces, corrupt relationship with the service provider, inappropriate social relationship with the service provider, and members raising concerns relating to the above were removed from their general post by General Pashlani. And over the page, IPID received the complaint on the 25th of February 2016, and General Pashlani was informed about the complaint in writing on the 18th of March 2016 by the then acting head of IPID, and was acknowledged by General Pashlani on the 9th of May 2016. There was seemingly no investigation or movement relating to the investigation during the period whilst Mr. Kamanyani was acting as the executive director. The complainants approached the executive director and raised concerns about the lack of progress made on the investigation. The executive director then appointed a team led by Mr. Mandla Mashlangu to investigate the allegation on 1 November 2016. Upon the establishment of the team, witnesses were identified and interviewed and statements obtained. Just to interpose, and hopefully we can agree on this, General Pashlani, maybe for the first time today, just to provide context. At the time when the complaint was lodged, Robert McBride had been placed on suspension, and Mr. Kamanyani was appointed as acting executive director. When Mr. McBride returned, this complaint that was lodged was then revised or revisited, sorry. So just to continue, soon after the investigating team started the investigation, the investigating officer, the complainant, as well as the executive director, started receiving death threats by means of text messages. The investigation established that on the first threat, the phone used to send text messages was linked to a police officer based at OR Tambo. The investigation also established that the second threat was made from a phone that received reception from 3G SAP's Intel tower. When General Pashlani became aware of IPID's approach to witnesses, he contacted witnesses and instructed the witnesses not to cooperate with the IPID investigators. IPID then opened a defeating the ends of justice case in November 2016 as the Camel Drift case. General Pashlani then made public statements on several media platforms that he's going to establish a team to ostensibly investigate security breaches. Instead of approaching SAP's protection services for the alleged security breaches, General Pashlani appoints a team from Northwest under General Mabula to investigate the so-called security breach. The team he appointed is a team that is under investigation by IPID for various offences, including murder, torture, assault, defeating the ends of justice. The DPP has already decided to prosecute them on the torture cases dating back to 2010, and warrants of arrest were issued. IPID is awaiting the DPP decision on the centralization of the above matters. Mr. Paul O'Sullivan and his assistant, Maseret Jane Trent, were charged for, amongst other charges, impersonating an IPID investigator in terms of the IPID Act. The Mabula team then started interfering with IPID investigations by interviewing IPID witnesses which had already deposed statements to IPID relating to the General Pashlani investigation. The Mabula team also unlawfully arrested one of the complainants, Mr. Paul O'Sullivan. Advocate Mashucha issued the warrant of arrest. The Mabula team obtained a search warrant against the complainant, Mr. Paul O'Sullivan. The investigating officer, Brigadier Nkube, in the application for the search warrant indicated that the threats from Mr. Paul O'Sullivan started on 12 February 2016. However, the case of intimidation and other charges was only opened in January 17. It would appear that there was never a concern about the threats or the IPID investigation on General Pashlani until the executive director appointed the IPID investigating team and the investigation against General Pashlani started in earnest. General Pashlani instituted civil action against IPID and the magistrate to issue the search warrant, not seizure, to General Pashlani's property. The civil action is at state expense. General Pashlani unlawfully obtained Section 205 applications by IPID from the magistrate's court file, which was not related to the search and to which he was not entitled. It is a shocking abuse of power that General Pashlani now has access to the IPID investigative information and would compromise the investigation, as the details of those subpoenaed in terms of Section 205 of the Criminal Procedure Act is now known to him. It is possible, just as IPID members have received death threats, that these witnesses may be intimidated or have their lives threatened to ensure that they do not cooperate with the IPID investigation. The Mabula team charged IPID investigators, Mr. Mandla Mashlangu and Tamani Binang, on charges related to the investigation of General Pashlani. We have since learned that they have now opened money. We have received information from reliable sources that the Mabula team is now actively involved in countering investigations against them related to the murder and torture cases. And we have since opened another defeating the ends of justice case at Pretoria Central. IPID views this interference with the investigation by General Pashlani and General Mabula's team as detrimental to IPID's independence and offends the legislature's objective about IPID Act provided for in Section 2 of that Act. Any investigation by any member of the SAPS against IPID investigators, because they are being investigated by IPID, defeats the whole purpose of the independent oversight of SAPS as provided for in Section 206 of the Constitution, confirmed in the Constitutional Court judgment, and is a clear conflict of interest. Officers who are subject of IPID investigation should be allowed to investigate IPID as they are conflicted. The actions of General Pashlani and General Mabula's team are in conflict with the stated intention of Parliament and the legislature in creating IPID. This conduct is criminal and undermines Parliament. The will of the people of South Africa as represented by Parliament is also undermined. IPID has instructed its legal team to issue letters of demand to General Pashlani and General Mabula to desist from interfering with the IPID investigation. Failure to comply will result in IPID approaching the High Court to interdict them. And in due course, I'll get to that case that was brought in the High Court, and a judgment was handed down. We have written to the NDPP raising concern about the summons against our investigators on charges related to the investigation of General Pashlani and perceived collusion by some prosecutors in assisting the Mabula team to interfere with the IPID investigation. IPID is convinced that it will be in the interest of justice for General Pashlani to be suspended or put on special leave to allow IPID to continue with the investigation without any interference. Amendment to the IPID Act must also address this issue to discourage any future interference. This is the annexure which you fairly, General Pashlani, has attached to your affidavit and your response.
I must now respond to what you are reading. Okay. Must I respond? My response, if I'm allowed to, is well captured in the documents, in the minutes of Parliament, JKP 23, dated 16 May 2017. Because that is the day that we were in Parliament and that presentation was made. And that response is well traversed here. But I will go and politely read some of the issues that I'm referring to in respect of JKP 23. And I'm going back paragraph on page 58, paragraph 129. I'm trying to make it easy so that I just capture the facts. 129, the following day, 11 May 2017, Mr. Francois Biekman, chairperson of the Portfolio Committee, addressed a response to my letter of apology to attend a meeting of 16 May 2017. The letter is annexed here to SJKP 21. Upon receipt of the said letter, I rearranged my trip and duly attended. On 16 May 2017, I went to the meeting prepared and armed with a comprehensive presentation that will give a detailed account of the very same allegations presented by McBride. I annexed here to marked JKP 22, a copy of the presentation that was made to the Portfolio Committee in the presence of McBride. My appearance before the Committee on Police was to respond to the same allegations made by Robert McBride during his previous appearance on 4 May 2017, where I was not present. Robert McBride alleged that it was unprecedented for him to have been called to the committee to account on investigations against me in my presence while he was the initiator, the author, and the narrator of the script. I say so in my affidavit. It was during the said meeting that I characterized IPID as a captured state institution by Mr. Paul O'Sullivan, I opined that it was O'Sullivan Police Investigative Directorate, OPID. I annexed here to marked JKP 23 a copy of the transcribed deliberations recorded by PMG, a service provider rendering recording services in Parliament. I annexed here to mark JKP 24 a copy of the minutes taken by a committee officer of the Portfolio Committee. It is here where I pause and take the nation into confidence on Robert McBride's war waged against me. His well-orchestrated campaign through the media, with Paul O'Sullivan on various platforms under the pretext of fighting corruption, systematic corruption, and maladministration. It is apt that I deal with the overview of the allegations made against me, and when necessary, I will annex relevant document to substantiate my submissions. 134. Robert McBride must indeed be credited with having learned exceptionally well from his masters and handlers in unleashing a propaganda machinery on a target and in being relentless in his efforts to cause harm and reputational damage to those in his sides. The stratcom that was waged against the struggle seems to be what he admired, and he did not let an opportunity to pass without him applying such to his benefit. I salute Robert McBride in this regard, this despite the pain and hate directed at my person and the character assassination I endured. I had never met Mr. McBride in person until Saturday around midday during April-May 2016. Like you said, SC, April-May 2016, when you say he was on suspension, it is true, but he was under suspension from his post as executive director of IPID. When I was surprised by his presence outside my house in Sable Hills, the very famous McBride O'Sullivan playing field, I was with a fellow resident, Mr. Yuan Smith, may his soul rest in peace, who visited me to discuss matters related to the Homeowners Association. When I walked him out, he mentioned a person he was expecting who happened to be Robert McBride. It was here where Robert McBride came out of the driving seat of a white E200 Mercedes-Benz vehicle in which he was driving with a female passenger. We exchanged greetings. Mr. Smith allowed us space to briefly engage without any interference. At the time of this unexpected meeting, the media was running articles and stories by Pope Crew and O'Sullivan's allegations of corruption leveled against me. You will have noted as part of the records that twice on the 30th of June 2017, the late Judge Monama ruled in my favor on a civil litigation against the very same Pope Crew members. Recently, on the 5th of November 2025, the full bench ruled in my favor on that particular litigation. And it was found that the allegations made against me were baseless, and thus they are to pay me costs, and they are to retract the allegations that were being made and tender an apology. So these are the same people that I'm being told they are witnesses in McBride's pursuit against me. Or O'Sullivan, for that matter. There is not a single case docket. Of all these concocted dockets, there is not a single docket which contains an affidavit by Paul O'Sullivan. Not a single one. Now, we talk here about the period with Khamanyani, when he lodged that complaint. I know it's a thick thing. Those who understand law will realize that this person was just going to town about everything else. If you accuse me, come directly. Let there be the elements of crime in that particular affidavit. I don't know what elements of crime we were able to find. But Khamanyane appointed a team of investigators to investigate that particular allegation. Even if there was nothing direct on me, they went to O'Sullivan. Brigadier Homo, who came back to the police, was one of the investigating officers. I think there was a Mr. Malema or Marema, but there were 3 people who were investigating. They went to O'Sullivan and say, in view of this newspaper, which you say it's an affidavit that you have, can you depose a sworn affidavit so that we can investigate properly? To date, that was not done. On the day that McBride came back to he called those investigating officers, they were in KZN. He called them back to office. When they arrived, the morning, by the way, I've got records there of from the Section 70. He had received a call and a WhatsApp from Sarah Jane Trent, who is an assistant or whatever of Paul O'Sullivan, who's asking him, McBride, where are you? And he say, I'm on my way to the office. This lady say to McBride, I'm on my way to bring a Pashani dossier. This is McBride, who was on suspension, that came to my office. First day he rocks up in office, he gets from O'Sullivan the so-called dossier. The same afternoon, when those guys came back from Durban, he removed them from the investigation. He took the dockets. That was the birth of the Pashanitas team. So, in paragraph 137, during this brief engagement, Robert McBride told me he was aware I was under attack from people who did not want me to be in the position as I was in and the work I was doing. He mentioned that those people did not want us. Now we now happen to be in the same bracket. They do not want us good people, and they will do everything in their power to fight us. He further mentioned that they were using the media to attack and that we should be careful. McBride said, I should be careful of the Minister of Police, referring to Minister Nathi Nhleko, and the former head of the Hawks, Major General Ntlemeza, who were allegedly behind the attack on us. Robert McBride offered assistance and said we should work together in dealing with these people. Who are these people? I must work with him to deal with the minister and deal with Ntlemeza, who were trying to get us destroyed and replaced by people of their own. He also offered to work with his contacts in the media because media people wielded power. I listened attentively, we exchanged cell phone numbers and agreed to keep in contact as and when the need arose. My response to McBride was that there was nothing to worry about with the allegations made in the media, considering I had done nothing wrong. I indicated to McBride that it was important for the allegations made against me to be thoroughly investigated, for the truth to be revealed. Robert McBride and I parted, and he followed Mr. Johan Smith to honor their engagement. I was left in disbelief and shock. I have never shared this conversation with anyone other than my wife. That's what happened on that particular day. So, on the 5th of June, my wife and I were attacked by 3 gun-wielding men while at a spa in Duncanfell, Johannesburg. I remain grateful to the Almighty that we survived the attack, even though we sustained some injuries during the unfortunate incident. following the attack on 5th June at about 1934, the first person who called me was Robert McBride. Robert McBride sent me a text message via WhatsApp which read, "Just heard. Sorry about that. Let me know if you need help. Offer still stands." Which offer still stands? I responded at 19:30 to his message as follows: "Noted with appreciation, kind regards." That's where I left it. I was taken aback months later in 2017 when I found out that it was Robert McBride who obtained a copy of the CCTV camera footage and recordings of the attack, forwarded it to Paul O'Sullivan's assistant Sarah Jane Trent and Peter Louis Mayberg, who circulated such via YouTube with distorted reporting to the media. Robert McBride returned to office as the executive director in Independent Investigative Directorate from suspension on the 18th of October 2016. So I'm going through this so that I properly respond to what you are reading, SC, because these issues are traversed. I'm not under trial on what McBride is saying. He must come and say, I am putting my version, which is important that it be communicated and not be brushed aside. The attacks directed at me by Robert McBride and O'Sullivan and their sustained campaign through the media, both print and electronic, bears testimony to their control of individual journalists whom they weaponize against me. A propaganda machinery unleashed by McBride and O'Sullivan was spearheaded by a select group of journalists whom I know, by the way, and I'll name them here if need be. Marian Tem is one of those people. Who was this? The late Karima Brown? She's one of those people. Abraham Mashiro is one of those people. Barry Bateman is one of those people. There is a whole list of people that in one of the WhatsApps, actually, you have here the WhatsApp exchanges between Sarah Jane Trent and the late Mandla Mahlangu, who was the investigating officer. Even Karen Vaughan is here. So you have got a whole range of people that were working on the Pahlane project.
Were you done on the part that you were reading?
I'm not done, Chair, but I think I must respect the committee's time because he decided to go and read Robert McBride's allegations, and these are properly responded to. If I was here to be taken through my affidavit, these issues would have been traversed. So I'm going to pause. I can deal with some of these things when we come back.
Okay. It's now almost 10 minutes past 5. We are going to break and come back at 5:30.